Good morning, everyone, and thank you for joining this Ius Laboris webinar. Today, my name is Alessia Perez, and I will be facilitating the session for you today. Today's webinar will be given by a set of panelists, all from different member firms of Ius Laboris. Today, we have lawyers from Australia, Austria, Belgium, Hungary, and Italy. Before we kick off the session, I would like to clarify a couple of points on the housekeeping side. If you have any question throughout the session, you can use the Q&A tab that you can find just below to send your question to us, and the panelists will answer as many as possible during the Q&A session, the last 10 minutes of this webinar. You can, of course, also reach out to the panelists by email after the webinar. I will now turn over to Aldo Palumbo, our lawyer from Italy, from Toffoletto De Luca Tamayo, the Italian member firm of Ius Laboris, to begin the session. Go ahead, Aldo. You're welcome to start.
Thank you, Alessia. Good morning, everybody, and thank you for joining. I'm Aldo Palumbo, as Alessia said, and in this occasion, I'm acting as chair of Ius Laboris Diversity and Inclusion Expert Group. Together with our speaker, Katie Sweatman from Australia, Birgit Vogt-Mayerecht from Austria, Sarah Kloitz from Belgium, and Hedi Bozonik from Hungary, we will be discussing the growing impact of AI on recruitment and HR process and the potential risk that can derive from. We will compare perspectives from different countries with the aim to give you a practical insight on managing discrimination, privacy, and other legal risks. Let's speak briefly about Artificial Intelligence Act. Each AI tool may fall under high risk or unacceptable risk. This applies, for example, to a system intended to be used for recruitment or selection, to make decisions affecting terms and work relationship, to allocate tasks based on individual behavior, and even to monitor and evaluate the performance. AI is not by itself discriminatory. It's just a tool, but it depends how it is used. When an algorithm is misused, it can produce direct and indirect discrimination that are respectively: one, a situation in which a person is treated less favorably than another in a similar situation, and indirect discrimination, a situation in which a provision, criterion, practice, act, or behavior, even if they appear neutral at first glance, may put a person at a disadvantage in relation to another by reason of sex, religion, personal beliefs, and so on. So, to go deeper in this topic, I'm asking to Sarah and Birgit some questions related to AI recruitment and discrimination. In what way does AI create potential risks for discrimination law? What are those legal risks? And how can employer manage those risks? Sarah, what do you think about it? Sarah, you're on mute.
I'm sorry. live issues. I'm sorry. Thank you, Aldo. Well, that's an excellent question, and one that's becoming increasingly important as AI tools become more and more common in recruitment. From a Belgian and European law perspective, the main concern is that AI systems can replicate or even amplify the human biases that are embedded in the data on which they are trained. For example, historical hiring data reflects gender imbalances, age preferences, or cultural homogeneity. The algorithm may learn these patterns and reproduce them systematically. So what appears to be a neutral, data-driven process can therefore produce outcomes that are indirectly discriminatory. Belgian equality legislation, and in particular the three anti-discrimination acts against gender discrimination, against racism, and for the general one, against discrimination based on all other protected criteria, prohibit both direct and indirect discrimination in access to employment. These obligations apply irrespective of whether the decision-making process is human or automated. The key point here is that the employer remains responsible for the outcome of the recruitment process, even if it relies on an external AI tool or a third-party vendor. Indeed, the use of automation does not transfer the legal responsibility, and employers must therefore ensure that both the design and the use of these tools comply with Belgian and European standards on equal treatment, data protection, and privacy. When we look more closely at the legal risks, well, several stand out. The first and the most obvious one is the risk of a discrimination claim. A candidate, or also the Belgian equality body UNIA, could challenge a recruitment process that produces disproportionate results across protected groups, even in the absence of any discriminatory intent. A second major risk relates to transparency and explainability. Belgian courts and the Belgian Data Protection Authority increasingly expect employers to be able to explain how recruitment decisions are made. Under both the GDPR and AI Act, candidates have the right to human review and to an explanation when automated decision-making affects them. If an employer cannot provide that explanation because the other algorithm is a black box or its logic is opaque, well, that creates real compliance issue. The third layer of risk lies in data protection itself. Many AI systems rely on processing large volumes of data, often including sensitive or inferred data. Profiling and automated decision-making in recruitment constitute high-risk processing activities, which means a prior data protection impact assessment is required together with appropriate safeguards. Finally, there are also potential implications under collective labor law. When AI tools are used to assess or select candidates, they fall within the scope of collective bargaining agreement number 39 on the introduction of new technologies. This CBA requires prior information and consultation with the Works Council 1 month before introducing new automated systems that can influence hiring or evaluation decisions. So, how can employers manage these risks in practice? Well, the starting point is to conduct proper due diligence on any AI system before it is implemented. Employers should understand how the tool was developed, what data it was trained on, and whether the provider can demonstrate compliance with European discrimination and data protection standards. Once the system is in use, it is essential to maintain genuine human oversight. AI should support and not replace human judgment, and recruiters must always remain responsible for the final hiring decision. Employers should also carry out regular testing and bias monitoring to ensure that the tool does not produce disproportionate effects on specific groups. These audits should be documented, as this can serve as valuable evidence if a process is ever challenged. Transparency with candidates is equally important. Applicants should be informed when automated systems are part of the process, and it should be explained in clear terms how fairness and human review are ensured. Finally, employers should integrate the use of AI into their existing internal policies, recruitment, ethics, and data protection, and provide specific training to HR staff so they can critically assess and interpret AI outputs rather than simply trusting them as objective. In short, AI in recruitment can significantly improve efficiency and consistency, but it does not reduce the employer's legal obligations, quite the opposite. The guiding principle in Belgium remains that human accountability applies to all automated decisions. Employers must ensure that recruitment process remain fair, proportionate, and transparent at every stage. And that actually connects quite nicely with what we're seeing all across Europe, as my colleague Birgit from Austria will further explain.
So thank you very much, Sarah. This was very interesting, and I fully agree with your remarks. And I can, well, not surprisingly say the situation is not so different in Austria. But still, I want to add a few principles and a few specialties in Austria. want to start with a point that we see with many companies, especially if they are using AI systems that have not been developed within the EU, so that they are struggling with additional questions around how have they been created and have the values and principles that you mentioned been taken into account with that. So that's an additional issue. And we also see with companies making use of AI that they are not that aware so far that they have to train their employees accordingly. So it is a main principle in Austria as well. And as the AI Act came into effect a few months ago, employers have to get ready for this, and that they train their employees accordingly, so that they, on the one hand, know what are the forbidden AI systems, what are the obligations and regulations that they have to take into account, so that they have to prepare certain trainings, that they have to take care, that they have a specific guidelines where the employees can have a closer look to find out what are their responsibilities. And especially, on which I come back later again, is on what is the use of AI in this specific company. Otherwise, and this is something that reminds me a bit of the data protection issues, there are severe fines that can be imposed on the companies, which are between or up to 7.5 millions or even 35 millions, depending on the type of violation, and it may even be 7% of the global revenue of the group of companies. So this might be severe fines, so that the companies have to take care that they are prepared and don't start AI use unprepared and without specific regulations. So we see with many companies in Austria that they are making the decision, how do we go on? Because as it is not a very like used field of law, they are making the decision between, do we prohibit AI use as such? But they see many competitors make use of AI. So at the end of the day, they would be in disadvantage concerning their competitors. So what they do is to try to find out, can they use internal AI systems? And I see that quite commonly right now, that they are implementing AI systems, making use only of restricted data to avoid the problems that you mentioned. And others are also using customized generative AI systems where they try to, let's say, reduce the risks that you mentioned, because all of us are a bit like struggling that the data that is available is created perhaps with biases, with discrimination. And even if you make use of them in a good way and don't want to discriminate, that the data itself may be discriminating. So at the end of the day, they are struggling that the AI systems require that you make certain protective measures. And one that you already mentioned, Sarah, is this high risk systems. And surprisingly, because you would perhaps at the beginning not think that HR management would fall under the scope of it, but it is, and especially decisions that are essential for the business or professional life, like hiring, like promotion, but also termination, are considered to be high-risk systems or part of high-risk systems. And this is why you have to take care, as you already mentioned, that there is always the man in the loop. So you may use an AI system, but you make sure that you take care that there is human control, and it's not the AI system alone that makes use of it. An exception from that is only made in cases where you make use of a system that is only preparing data. But also there, as you mentioned, it has to be taken care that the system itself is not based on already biased data. So at the end of the day, it is something, it has to be closely looked at. Which system do you use? Is it a high-risk system, as HR management is, as we mentioned? And what types of obligations do you have in this regard? And one thing that I think, as I've seen in practice in the last weeks, is not taken into account by all companies is that they even have to take care and have to review the data and have to implement principles and, as I said, training and also some legal guidance, is that also companies that are not developing AI but only using it have to basically take care and have to review the data and also especially the content that is created with these AI systems, so that it is made sure that there are not discriminating data used, and to make sure that at the end of the day they are taking into account all the principles made. So also smaller companies, which are perhaps not that keen on AI, will have to have a look at this, because as we all know, many people are already making use of AI in their private life. We hear about 2/3 of all people, like between 18 and something, are making use of AI. And as employers, we know what is used in private will be used in business as well. So it is up to us to take care of this. And it is also the small companies that have to have a look at what are their specific obligations. And one point that has to be taken into account in this regard as well is the role of the Works Council in this regard. So there are information rights, there are even rights that they have to be involved concerning perhaps the training of the employees, and there are also co-determination rights that may come into effect in this regard. If it's about evaluation, if it's about control of employees, but also already based on automated decision making, or automated use of data in HR or in HR processes. Austrian labor law requires that the works agreement is concluded. So you can see there is a couple of issues that you have to take into account. Works Council, employment, individual relationship, and as Sarah already mentioned, in Austria as well, there are strict equal treatment regulations that have to be taken into account. And as the European Court of Justice mentioned, even if a company does not discriminate a single employee or a single candidate that is applying for a job position, it may be discriminating if the company as such applies rules like saying, okay, we don't employ any homosexual employees, or we don't employ any homosexual candidates. So the ECJ said even this may be discriminating, and especially with systems that are used in the background and in recruiting, employers have to take care on that very, very, very carefully. And also we see trends from the US, and you may be aware that there has been this decision that gender bias has been created by use of historic data. So the company basically only wanted to make use of what has been done in the past. But since there have been more male than female employees in this data sample that was used, it was considered to be gender bias. And I think that many of these data systems, AI systems that are used, will face similar problems. So it has to be taken care of that the data used, as I mentioned, especially is if you use internal systems, but also externally, how have they been created? Are they taking into account this equal treatment principles properly? So it is up to the employers to make use of the AI systems to not to stay behind their competitors, but still they have to take care that they are accurate, ethically founded, fair, non-discriminatory, and so that the employees also know when they use and are implemented in HR process that they have to make the use of AI transparent and take care what types of AI systems they are using in this regard.
Thank you, Sarah. Thank you, Birgit. That was very clear and helpful. Going deeper into the recruitment process, I have a question for Heidi and Katie. Based on your experience, what would you recommend to recruiters to avoid being accused of discrimination? What question can and cannot ask candidates? And a second question for you both. What will be, in your view, the impact of the forthcoming Pay Transparency Directive on the recruitment process? We know that it's not already in place, but we are going to arrive. Heidi, what is the situation in Hungary regarding what you can and cannot ask? And then Katie, does something similar to this EU piece of legislation exist in Australia?
Thank you, Aldo. In Hungary, you can only ask candidates for data and information and to make statements that are relevant and necessary with respect to the establishment of the employment relationship, for exercising rights and meeting obligations. Questions that are unrelated to the employment relationship cannot be asked. And if these questions are asked, then candidates are not obliged to answer these questions. As a general rule, sensitive data cannot be requested. Questions relating to the candidate's protected attributes such as racial, ethnic origin, political opinion, religious belief, health, sexual orientation cannot be asked. These are all prohibited. Even questions relating to the employee's age or the candidate's age may be considered discriminatory. The same applies to photos. Employers cannot ask for photos anymore from applicants. Questions relating to the applicant's trade union membership or the candidate's financial state are also prohibited and cannot be asked. As a general rule, biometric data, think about, for example, a fingerprint, cannot be processed. This is the general rule. There are exceptions applied, but they are very few in numbers. The same applies to clean records, so criminal records. It used to be a practice, and I used to see it in many of the employment agreements that clean police records are requirements for the establishment of the employment relationship. This is no longer a practice that is permitted. As a general rule, clean criminal records cannot be requested from employees and from applicants, except in justified cases that are all defined by the law, mainly by the labor code. Such exceptions are if somebody has to work with children or when it's particularly relevant with respect to significant financial interest of the employer. In Hungary, we don't have the EU's Pay Transparency Directive implemented so far. Once we do, it will be also prohibited to ask candidates about their previous salary history. You can ask, and you will be able to ask candidates about their salary expectations for the specific role that you are offering, but you cannot ask for salary history or data with respect to their previous salaries they received. We also have strict rules relating to aptitude test or competency testing. These tests are designed for measuring the employees or the applicants' various cognitive skills and abilities. For example, problem-solving ability or decision-making skills by presenting them to real-world situations or realistic work-related scenarios. These tests in Hungary may be used in 2 cases only: when prescribed in employment and in so-called employment regulations. Employment regulations include the law, so basically the labor code, collective bargaining agreements, and agreements with the Works Council. Employers' policies, so internal policies, do not qualify as employment regulations. So basically, for employers who don't have employee representatives, not a Works Council or a trade union, this competency testing will not be possible unless it's allowed by the law in very, very limited cases. The Hungarian Data Protection Authority also has a particularly strict approach to this testing. The reason is that these tests reveal personal and often sensitive data and sensitive information about the employees. So according to the Hungarian DPA's standpoint, employers are not entitled to learn the test results that are connected to specific employees. So the data must be processed anonymously, which means that practically the competency testing cannot be used for onboard or during onboarding process. It can be used for trainings, but not during onboarding. We realize that this is a probably unnecessarily strict approach, and we see that employers are there is a growth in the need to go with the word. The word passed this practice, to be honest. So we are expecting that this strict approach will be at some point lifted, but this is what we have to live with at this point in time. If we are at the very strict approach of the Hungarian DPA, I also want to share with you a very peculiar practice relating to recording employees' identification documents. These documents include identity cards, passports, address cards, and other documents containing specific identifiers such as social security and identification numbers. The DPA claims that copying these documents is excessive from the data protection principle, and therefore is not in compliance with the law. Instead, they advise employers to record the data from these documents and ask the candidates to fill out a statement on in which they declare which document they have delivered or which document they have presented. But once again, copying is not allowed. We also see some kind of lifting probably on the longer term of this very strict approach. But at the moment, this is what we are advising our employers to meet with. In summary, the limitations of the labor code must be observed as a basic rules during the onboarding process in Hungary, and additionally, the data protection rules and the GDPR must be also observed. And once implemented, the EU's pay transparency rules will also have to be met. And a very fresh update, in Hungary, we also implemented the national implementation of the AI Act just happened. The act was published on October 31st, and it will enter into force on December 1, 2026. And the national authorities, so that are required by the AI Act, the EU's AI Act, so the advisory body, the notifying authority, and the market surveillance authority has been established. We are still learning the names of these authorities, so it's a very early phase. But once basically the AI directive or the EU's AI Act is directly applicable in Hungary, but the rules are now refined and available to everyone. So we will also have to observe the AI Act rules in addition to all the above or mentioned. Thank you.
Thanks, Hetty. And hello everyone. Good evening to everyone who's joining me from APAC and Australia. It's funny to be on two very different time zones across, so it's really exciting to be here with everyone. And I've been loving hearing about the European experience in this space, and some of the things that are very similar and some of the things that are very different. I want to talk a bit about what you can be asking in respect of AI recruitment and in requests more broadly. And Aldo, you asked a great question about how Australia might be a bit different in respect of pay secrecy. And it's interesting because we're actually quite different to what the experience is in Europe. And in Australia, we've recently had pay secrecy laws introduced, which prohibit someone from requiring an individual to keep their pay as a secret. And so it's been identified, or that the theory is that by allowing people to speak about their salaries and to be able to discuss that in a more open basis where they're comfortable doing so, that may flush to the surface where there are discriminatory pay practices in place. And so it's really interesting trying to achieve the same sort of objectives of equality, but in very different ways, and what the impacts of those things are. I do have to say that even though these pay secrecy laws came in around sort of 12, 18 months ago, I don't think we've seen an awful lot of change in practice, save that there is a lot of reporting that has come alongside those pay secrecy laws. And so large companies need to report what their salaries are, and that gets published. And so we can see where there are pay differences between men and women, which is really interesting and having really interesting outcomes. And certainly in terms of the potential discrimination issues that can arise, Australian employment law takes a reasonably similar sort of approach. There's been some really interesting research that's been undertaken by some of our local academics, looking in particular at this concept of proxy discrimination and how that fits within the Australian framework. Now, what I mean by proxy discrimination is where AI systems tend to flush out these types of qualities that connect what is a good candidate in a recruitment process. So picking up something that Hetty was just talking about, quite famously, there was an incident involving one particular recruitment program where it was found that by a large employer feeding in all of the information about its highest performers, what this recruitment program started selecting on the basis of, and finding that it found that the two factors that were most determinative of high performance in a particular role, that was that your name was Jared and you played lacrosse at high school. Now, those things on the face of it may not appear to be discriminatory. They're absurd when they're highlighted. But what that shows is that what it did was it amplified bias towards men. And what it also did was it amplified a bias towards probably what was more private school education and men coming from a more privileged background. So it's really important to be approaching the use of AI tools to be thinking about, well, what are the things that we require for a role, and what are the types of characteristics that won't necessarily result in these discriminatory outcomes. And so it's really important for employers to be looking at, for a particular role, for a particular position description, what are the qualities of the person that we want to have performing this role, and to be having the AI system mining those types of qualities from the inputs that are going into the recruitment system. So the types of qualities that will go to being able to demonstrate strong sales performance, being able to demonstrate strong resilience, being able to demonstrate the types of qualities that you need in a role, and avoiding things such as the types of matters that Hetty and Birgit and Sarah have mentioned. Another one that I thought of as Hetty was going through her discussion, which tends to work against women, is where recruitment systems pick up where someone has had career gaps or unexplained gaps in their career, which on its face may be viewed to demonstrate that someone has had inconsistent employment history, and that might be a red flag. But what that can also be an indicator of is that of a woman who's had periods of parental leave. And so it's really important that there's that intervention to be able to identify where requirements of a role are actually manifestations of a particular discriminatory view of who we want to have in a particular role. Because AI, in the same way that humans apply judgment and their own biases to decision making, AI will only amplify that because it is really drilling it down to its bare elements. So I think with that, I'll hand back to you, Aldo. And what's the Italian experience with some of these things, or did you want to talk about some of the other sort of issues coming out of AI discrimination?
Thank you. Thank you, Heidi and Katie, for your insight, and thank you for asking, Katie. Actually, in Italy, let's say we are starting dealing with AI, moving from our basic principle, that is, you can ask questions which are unrelated to the employment relationship, so that if you cannot ask, you can ask AI to ask this on your behalf. So what we are doing is testing AI system in order to avoid that such questions are introduced in the let's say in the recruitment process through the AI. But we are moving step by step just to learn and understand how to use AI, especially in this aspect. But the principle is that you cannot ask personal opinion, religious belief, sexual orientation, family status. And as far as the Transparent Directive, just to link to what Heidi say, also in Italy is not implemented. Also in Italy, for this time being, it's not prohibited to ask something about the candidate about their previous salary, but we are moving from a different approach in order to anticipate this step and try not to ask this and try to move around in order to be able to have, in any case, effective recruitment process, but already getting used with those new rules. Finally, before closing our webinar, we would like to move a little bit to a different topic, a very hot topic, which is the background check carried out before hiring a candidate, with a focus on a background check carried out through the social network. It's a very, very, very hot issue, at least in Italy, because the risk is to collect information that are not justified in order to start an employment relationship. Last question then to all panelists. Based on your experience, Sarah, Birgit, Heidi, Katie, are employers allowed in your country to carry out background check before hiring a candidate? And can employer use AI or social network for this purpose? We have 3 minutes each.
Thank you,
Sarah.
Aldo. Well, in Belgium, the general principle is that background checks, including on social media, are not prohibited per se, but they are subject to strict conditions under both labor law and data protection regulations. In particular, collective bargaining agreement number 38 on recruitment and selection of employees, while it provides that employers may only collect information from applicants if it is relevant for the position in question. This means that any background check must have a clear and direct link to the job requirements. Now, well, when it comes to collecting information from third parties, which is often the case in background checks, the Belgian Data Protection Authority imposes 3 cumulative conditions. The first one is necessity. The intervention of a third party must be essential. If the employer can reasonably obtain the information directly from the applicant, this should always be the first step. Only if the applicant's explanation is insufficient And here Katie already gave the example of unexplained pay gaps in a resume. Well, this could be the case here. This could justify an external verification in this case. The second condition is the explicit consent, since the applicant must have provided clear, informed, and written consent, including details on the third parties involved, the nature of the data being collected, and the purpose of the check, and the duration for which the consent remains valid. The third and last condition is the transparency. This means that even with consent, the employers must inform the applicants every time they reach out to an external source. As you might expect, this creates additional layers of complexity in the context of AI tools. Many AI-driven background check systems or automated screening tools might collect data from online sources, including social media. And if profiling is involved, for example, where an AI system categorizes applicants based on online behavior or based on language use, then enhanced transparency obligations apply. The employer must clearly explain the logic behind the profiling, why the categories of data are relevant, and how this affects the decision-making process. So, to answer your question, yes, employer can proceed to background checks, including on social media, but only under strict legal conditions. And if AI is used to conduct or assist with those checks, the legal thresholds, particularly around transparency, necessity, and proportionality, well, they become even higher. And employers should therefore proceed with caution and ideally seek legal advice when designing or implementing such processes.
Birgit, what about us?
Okay, so I take over here. For Austria, the situation is very similar. And as you already mentioned, Aldo, a specific issue in this regard is social media. So basically, we have the principle as well that the questions and the background check has to be in a concrete connection with the concrete job, etc. But when you use social media, data protection issues come have to be taken into account as well. So the question is if this information has been manifestly made public by the specific employee. So is it social media information that is publicly available if you go into the account of the specific candidate or employee? Or is it information that is on a private account and you are kind of an agent provocateur or somebody that is making a connection with the employee in this regard to find out more information? An additional issue that we have is that we have specific regulations for criminal background check that is allowed in specific industries, like especially in the industry of arms, in the industry of security industry, but also, for example, with regard to employment or lawyers in general, not only employment lawyers. We are required to look for a criminal record before we employ lawyers in our team. So you have a legal basis for this, but apart from that, similar as you mentioned, there might be the obligation to ask for the employee's consent in this regard. So it may depend on the specific circumstances, on the specific role, especially if you're looking for a managing director, if you are in a, let's say, a very delicate or dangerous field or things like that, where you have to take care what is the background check that you're taking into account. And one topic that is interesting in my view for Austria as well is that in employment law cases, you're basically not obliged to disclose the reasons why you made a termination of things. So at the end of the day, it might be that only if AI questions or if data protection issues come in, that you have to make a different assumption. But only from an employment law perspective, you may be allowed to make use of all these background check issues without any legal consequences or without any fines to be imposed. So this is from Austria. This is it from Austria, very shortly. And now Let's turn to Hungary.
Thank you, Birgit. The Hungarian Data Protection Authority has issued very clear guidance on this matter. Hungarian employers are allowed to conduct background checks, and they are also allowed to review the applicant's public social media profiles and activities. The emphasis is on public. So they can look at the applicant's LinkedIn, Facebook, and other profiles that are included. And however, four important notes from me in this respect. Only information that is relevant to establishing the employment relationship can be assessed, so such as professional experience, qualifications, language skills, and so forth. Data that is concerning the applicant's private life, relationship, family, whatsoever, religion, cannot be accessed. The second important note that what I mentioned, that the emphasis is on the public informations. So employers may only review publicly available social media profiles and may not access non-public profile data by any means. So very similar, as Birgit explained, as the situation is in Austria. So employers cannot, for example, ask employees to add them as friends, to gain a broader access, or to ask other employees for information that is available to them within closed groups. The third important thing is that while the applicant's public social media activities can be accessed and reviewed, and conclusions can be drawn from them, further data processing actions and operations are not permitted. So employers are not allowed to download, save, store, or share this information. And lastly, applicants must be provided always with prior information. They must be properly informed in advance that the recruitment process includes the employer reviewing their publicly available social media profile and information. The employers cannot just hide this practice from the applicant. And in addition, on the basis of the GDPR, you always have to have a legitimate interest to do this. So the basis for the data processing will be the employer's legitimate interest, and therefore, in addition to providing the applicants with appropriate information, employers will also have to conduct a so-called balancing interest test in advance to be 100% GDPR compliant.
Thanks, Hedy. It's really interesting to hear the European experience again and how that contrasts with the Australian experience. In Australia, if it's in the public domain, it's fair game. And so there's really no limits to how employers access publicly available information and use it and rely upon it. And there's no particular requirement at all to disclose that that publicly available information has been reviewed and accessed and considered in making recruitment decisions. And certainly when I'm delivering recruitment training to my clients, I have a slide where I say your number one recruitment tool is Googling the person's name and finding out so much about their background. Because certainly if it's publicly available, that's something that you can take into account. So it's really interesting. Where it does become a little bit more similar perhaps is in terms of how that's relied upon and the influence it has on decision making. And we had a really significant piece of litigation just earlier this year where our national broadcaster dismissed one of their journalists for particular political views that she was expressing on her social media. And so there was a lot of discussion both in the litigation itself, but in the broader Australian community around someone's ability to express their own personal political views with everything happening in the world, and how an employer or prospective employer can make decisions about those political views. And certainly decisions have gone both ways. There've been cases where it's been found entirely reasonable for an employer to make a recruitment or just dismissal decision on the basis of a person's publicly available social media posting, where that may impact the reputation of the employer or their prospective employer. But then in the Antoinette Lattouf case that happened very recently, views that she was expressing on the Israel-Palestine conflict, which is obviously very fraught, the way that they went about that decision and pulling her off air for expressing those personally held views was found to be unlawful by the court. So it's a really vexed area, and certainly something where employers should be seeking advice if they're making decisions on the basis of a social media presence, but having access to it and looking into it, not only prohibited in a lot of respects, we encourage it because it allows you to understand issues before they become a problem and cut it off at the chase. So I thought it was really interesting you were talking earlier, Hedy, about not being able to do competency tests until someone becomes employed. That's wild to us in Australia, because why would you recruit them when you're just going to have to terminate them during probation if it turns out they're not up to the job? So it's really interesting the different ways we approach it.
Thank you all. Thank you, Sarah and Hedy, Katie, and Birgit. Alessia, do we have some questions?
Yes, thank you very much. One question for Birgit. Can I file a complaint with the Data Protection Authority regarding AI systems?
Well, that's an interesting question, because it comes back to what has been explained by basically all the panelists, that there is a close link between data protection issues and the new AI responsibilities, or AI Act responsibilities. And the answer for Austria so far would be yes. Basically, if there are any data protection issues, especially if data of the specific person, of the specific data subject has been used and there has been a processing of personal data, the person could also approach the Data Protection Authority in Austria and bring their claim so far there. And similar to what Hedy mentioned before, there is no specific authority that has already been finally implemented in Austria in this regard concerning AI. There have been preparations. There is information available. There is like a service place where you can go there. But so far, if I would be an employee, I would rather go to the Data Protection Authority in this regard.
Thank you very much, Birgit. And a question for Sarah, for Belgium. How can organizations check an AI recruitment tool for bias if they cannot access the algorithm?
Well, I must say I don't understand much to algorithms behind AI tools, as I expect pretty much all of us. But well, even if we don't have access to the vendor's algorithm behind the AI tools, we can still check the tool for bias by looking at what it produces, at the outcome. In practice, that means that we have to test the results to see whether certain groups of candidates are treated differently, and we can also ask the vendor for clear documentations, things like fairness reports or explanation of how the model works, and so on. And for some tools that would be considered high risk, well, there it may be necessary to bring in an independent third party to run a more formal audit to ensure its compliance.
Thank you very much, Sarah. Shall you have further questions? You can reach out to our panelists via emails. We are sharing our slides with their contacts. And our panelists will remain available. We have a variety of resources and insights on our website, so don't forget to check them out. And for further information on our webinars, you can visit the webinar section on our website to find all the past recordings and download the slide decks. While you are there, you can also take a listen to our podcast, Talking Work, in which we talk about the world of work. Finally, I would like to thank everyone for attending this webinar, and a huge thank you to our panelists for their very interesting insights today. I want also to thank you, the attendees, for their positive feedbacks that they have left on the Q&A. And with that, the webinar will now be ending. Thank you and have a great rest of the day.
Thank you. Bye.
Thank you. Bye.
Bye-bye. Thank you, everybody.